Hello, welcome back to The Edge of Right. If you've been following us, you know that our firm has undergone a branding change. I'm Joe Graves. This is Matthew Thomas,
Hey, everybody.
and you got your T on the logo now.
Yep, I made it onto the logo.
Yeah. So the logo was just interlocking G's. A lot of people think it was snowflakes or
Some
what.
people say that.
Yeah, but it's really just interlocking G's. And since Matthew is playing major role in the firm now, I thought it was only fitting that his name and initial be in the logo. Plus, I mean, it was time for an update. I mean, last time we did a branding change was back in, can't even remember, 2010, maybe.
Yeah, I think, just updating it and staying current with our current approach and attitude towards the law, I think is great. I love it. I love the new logo. I love the new brand. It's really cool.
Yeah. So what we're going to talk about today is how small mistakes can destroy the value of a personal injury case. And the truth about a personal injury case is rarely decided by the crash itself. It's decided in the moments that follow. And after an accident, people stand at what Theodore Roosevelt called the edge of right, hence our tagline, the edge of right, meaning that narrow place where it had been easier to be careless or to be quiet or to take the convenient path. And when dealing with an auto accident or a claim, insurance companies understand something that most injured people do not. They are not waiting to help you. They're waiting to find that small mistake that allows them to pay less. Maybe a recorded statement was spoken too quickly, or a medical appointment was missed because life got busy. A photograph posted online and social media and that is taken completely out of context. Pain minimized because somebody or someone wanted to appear strong. The value of a personal injury claim is not built only on the severity of the injury, it's built on credibility, consistency, medical truth,
Definitely.
and discipline in protecting what really happened. At Graves Thomas, we believe justice begins by protecting the edge of right. If you're injured in Florida, the choices you make after an accident may be just as important as the accident itself, and the truth deserves to be defended. So, we're going to talk today about common mistakes that we see, you see as a group, as a firm, in our experience over the years that can devalue a claim. So, let's first talk about the insurance adjuster and contact. Insurance companies have a program, and I know because I used to work for a major insurance carrier, but they have a program and adjusters specifically trained, and their job is to contact accident injury victims before they have a chance to retain a lawyer. And they want to do that because they want to take statements, they want to try to get information, and I mean, they're trained to be friendly, and you think, well, they're on my side, and it may just be a lot more convenient because, I mean, our clients, 99% of them haven't been through this experience before. So, you're dealing with a lot of different issues.
Yeah, I think I've said this before, but I just want everyone to remember that insurance is an adversarial system because if they can collect premiums and not pay out in claims, that's the ideal business model for insurance. The second that it becomes a paying customer to a customer making a claim, that's where I think the dynamic changes in the interactions between the insurance companies. And you're right, when that insured or customer has proper legal representation, it's a heck of a lot harder for that insurance carrier to get the building blocks that they want in order to limit the amount of the claim that they pay out on the front start.
Yeah, we used to have a kind of a joke that, State Farm, your good neighbor until you have a claim.
Yeah.
And then the hands open, they're not such good neighbors anymore. But a
Yep.
couple of things that I see, in the course of the practice, and I can tell you from doing defense work, that I've seen this stuff on defense work, and is really kind of built how we do things now. representing injured people to make sure that our clients avoid these mistakes. But again, recorded statements. And when you start talking to an adjuster immediately after the accident, they're creating a record. You give a statement. And the thing with statements is that when you're being recorded and that's ultimately being transcribed, you're going to be held to those words. And people sometimes have trouble with things like estimating distance or estimating time. Or, I mean, our brains are not like video recorders where we have everything and we instantly recall every detail about what happened. I mean, we have something significant that happens, and then all of a sudden we're asked about it. And, I see people like they want to be helpful, and the adjuster seems like they're on your side. They want to be helpful. And so maybe some blanks get filled in with things that maybe you're not quite sure about, or you don't absolutely 100% know to be accurate. And that can become a problem.
For sure. I think the greatest analogy that I think of is when the police are investigating someone for a crime, do they want that person to have legal representation there, or do they want that person to uh, speak freely, and potentially incriminate themselves for the crime they're being investigated on? It's very similar with insurance. Does the insurance company, when they're investigating a claim for injury, do they want that person to have legal representation there, or do they want that person to make misstatements which are only going to help the insurance company in limiting how much they pay out? It's the same reason that those two entities in that adversarial system do not want you to have legal representation, because they know once you have that, now you're protected as long as it's good legal
Right.
representation.
And you're not, it's not an equal playing field because
Correct.
these folks are trained to get the information they want, whereas you're not.
That's right.
You probably have never been through something like this before. So it's not like you have anything to hide, but it just needs to you need to make sure that everything's 100% accurate, because this is credibility. We talked about that becomes really significant, especially in the eyes of an insurance company if you're trying to get something resolved. Things like guessing about what your injuries are, when you don't really know, or maybe going and not telling the medical professional all the things that are wrong with you. And it becomes difficult in the heat of an accident because your adrenaline's flowing. Your car may be totaled, or, how am I going to get to work? You got all these things running through your mind. But that history that you provide at the time, becomes important, because how many times have you heard of say, well, they didn't complain of, XYZ, when they went to the emergency room?
Right. Yeah, there's a lot of secondary issues that I think people don't view as important on, if they haven't been through the process or they aren't familiar with it, such as, you know, uh, numbness or tingling or radiating pain going down the arms, going down the legs. They're more focused on the actual pain itself, and maybe not the numbness or tingling sensation. So, because they don't understand the importance of that, or they're more focused on the actual pain, they might just say, well, no, this is it. I'm focused on the pain, not realizing that they're actually sort of undercutting their injury claim by not being fully descriptive of all the symptoms that they're having.
Yeah, another thing, happens is, you get into a significant accident and you're kind of banged up, you're kind of sore all over. Um, and you may, "Oh, I'm just sore all over." Well, as time goes on, some of those, some of that soreness is going to dissipate, and some of it may not. So it's just important, to make sure that everything's accurate. And like, if you think that you have this injury, if you're experiencing pain, that you tell your medical professional about it. Um, I can tell you on the recorded statement issue, we had a case a long time ago and ended up going to trial, but the person gave a statement before they were represented, and it became a big issue about coverage. And so the issue in that case was, did you disclose all the resident relatives that are living within your house? Well, in that circumstance, you know, somebody had temporarily left. And so residence and whether somebody lives in your house is like very factual. It's a multifactorial according to the case law. And it just created a problem. And then guess what? The recorded statement, the actual transcript was lost. So it just, those are the issues that can arise. Um and you And again, you think they're trying to help, you're trying to get things resolved, but you just need to be careful about that. Um, another issue is delaying seeing a medical provider. And in Florida, we talked about PIP. You need to see a medical provider within the first 14 days in order to secure your benefits, and then get an emergency medical condition evaluation for the remaining benefits that you have. But um, have you seen that? I mean, to me, I see it a lot because the folks that we deal with haven't been in an accident before, and like, I'm in an accident. This is gonna go away. I'm gonna get better. Because I think it's pretty much all around. People don't like to go visit doctors, you know. But that delay, what kind of effect can that have, Matt?
Yeah, delays are so interesting, Joe, because I think there's a lot to be said about the insurance company's approach to kind of make it you're darned if you do and darned if you don't. They're always going to find ways to try to attack your case, no matter what. I do think that that's an easy one for them. The longer you wait to go get medical treatment, the easier their argument is embedded into uh, the idea that you're not hurt, that you're kind of coming up with this pain or sensation later for secondary gain. So I encourage people to go to the doctor immediately just to get checked out to kind of curb that argument. So you're preserving it. But I would say that I don't want people to get frustrated by that concept that you're darned if you do, darned if you don't, because I think sometimes what I see is clients kind of want to throw up their hands and they're like, "Well, I can't do anything right by the insurance company, so what's the point?" And I would say, well, you have to put yourself in the best position to be able to prove your case, and the longer you delay, the more difficult that becomes.
Yeah, I think the interesting issue, and it's different, in a medical legal context, and I have to explain this quite often. I mean, if you're hurt and, for instance, you're hurting, you go to the doctor, you kind of shake it off, maybe. But in a car accident case or any case where someone's negligence has caused injury, the claimant has the burden of proof to prove that an injury was caused by a certain event. And the medical records become everything. They become the backbone of the case. And so that's why we've talked about documentation in the medical records, not delaying in your treatment. And it goes as far as, gaps in treatment too, because I've seen trials where they have a timeline. They'll put a timeline and they'll show like 1, 2, 3 treatment, then a couple of months without a treatment or whatever. And the argument, which I made when I was a defense lawyer, like, you ask a juror during voir dire, have you ever been injured before? And most somebody's had something. Well, did you go to the doctor? Did you treat? Oh, yeah. I
Mhm.
mean, so it's an argument that if you're hurt, you go to the doctor. If you're not hurt, you don't. And that's not necessarily always the case. In fact, I think some of the best cases I've seen are people that, they're not rushing to get a lawyer or rushing out to try to prove, a lawsuit or a negligence case, but man, they have something that just doesn't go away, and it is bothering them. And then they get frustrated with the process and then they end up, calling the office.
Yeah, that doctor-patient relationship, where there's a Socratic oath, and you have to remember for everyone, you really need doctors to be able to correlate your injuries to a specific event. It's called causation, to be able to prove your case. If you don't have a specific medical doctor who's going to testify or provide evidence that your injury was caused by the specific event, then you're going to have a real difficult time, almost impossibility in proving it. And so, if you know that, you have to give the doctors what they need to be able to make that determination. On the other side, they don't have treating physicians; they have retained experts. I call them jukeboxes because it seems like you put a quarter in, you tell it what to play, and then the song comes out. But these people don't have a doctor-patient relationship with the actual client. Instead, they're just retained by the insurance companies and the defense firms to tell someone they're not injured. But because they don't have that Socratic oath, they don't need to go through detailed, rigorous requirements to get them to a point to say it's not related, like your doctors do on the treating physician side. So I always tell people, give the doctors what they need to be able to make the decision and give you the information you need to be able to prove your case.
Yeah, that's interesting you bring that up about defense doctors. I think people get shocked, when I tell them, the defense is gonna hire a doctor and that doctor is gonna say you're not hurt.
Right.
And they're like, "Well, how could that possibly be?"
Right.
"I'm injured. I had this accident. I didn't have this before." And here's the trick. So a medical diagnosis is based on the subjective history. That's what you tell the doctor. Objective findings through like diagnostic testing, MRIs, X-rays. You have to have those components in order to render a diagnosis. The defense will hire a doctor that says, okay, you know what? I'm not going to pay attention to the subjective history at all. I'm not going to pay attention. And then they come out with an opinion that there's no objective evidence of an acute injury. Well,
They love that term.
that's probably
Very
true
true.
in just about every case. Okay, so say for instance, you take an X-ray and you have a fracture. You don't listen to the patient about what happened. How in the heck would the doctor be able to say, well, that fracture happened because of, this fall or some accident? You can't.
Yeah, it's a unique approach to get to the conclusion that they want to reach on the defense side. One of the first long trials that I was a part of, it was a 2-week trial, and it had two of the, I would say, premier radiologists in the state of Florida, and one was a Harvard grad and one was a Yale grad. And I remember sitting there. You were there, Joe, and I'm sitting there as a young attorney, over a decade and some years ago, and listening to these two doctors talk about this MRI scan. And one doctor is, and these are two both board certified neuroradiologists from Yale and Harvard for the people listening. So this is like the top of the top, they're graduating top of their class. They're staring at the same screen. One is going, look, that's a herniation, leaking disc material that's guaranteed to be causing pain because, you can see the compression and you can see the tears. And then the other doctor is looking at it going, I don't see any leaking disc material. I think that's too small to be a pain generator. And so I don't see any kind of evidence of an acute injury. And I don't see any kind of evidence of a permanent injury on the scan. There's two totally different visions of this one same scan. And I remember when I heard that, I thought, okay, this is like Rorschach testing. I mean, what are we even looking at here? Two people looking at a screen and saying the different things. So that's why the history, the physical exam, they all become an important factor, because if you just look at something in isolation, often like radiologists do, um, it's in the eye of the beholder almost to some extent, because even radiologists will admit that some people use the term bulge, some people use the term herniation, some use protrusion, and it's really about the radiologists themselves. So, yeah, you're right. You need that full formula to get to the mathematical equation that is causation opinions, and if you take out a part of that equation or miss a step, it's gonna allow you to get to the conclusion you want instead of the right one.
Yeah, and then, you bring up the physical exam, that's part of it as well, and it's just so subjective. Like, you have somebody just sitting there looking at you and, maybe they have you stand up or sit down or raise your leg or whatever, and their opinion is you're totally normal, and there's no, like, way to measure that.
Right.
You just have doctors, that are paid to say, um and I used to think they were just absolutely lying, and I think in fairness to them, what they're doing is when you take that subjective component out of the equation, it's almost impossible to know, how or if something's related.
Yeah.
Um, but
There's little things too with the doctors. We record all the examinations of defense doctors with our clients. So when one of our clients is required or compelled to go to a doctor visit with a defense examiner, we record it. And what I see a lot is it really goes towards bias, that the doctor has already made a determination of what their conclusion is going to be prior to the examination, because they've read records, or maybe because they know what song they've been told to play. I don't know. I can't get into their psyche, but I do see with the physical exam that oftentimes there will be portions of the physical exam where, for instance, heel to toe walk. Well, when you actually watch the video, the person loses balance. They actually can't perform the heel to toe walk. Um, but in the exam report, it says that it was fine. So, that kind of stuff happens where, they'll look away or they'll have a predisposed notion of what the person's able to do. And but for that recording, we wouldn't have any kind of way to contradict that the
Yeah.
person actually lost their balance, stumbled. And so I've had some really good results with impeaching the defense examiners with the CME video to show them that their physical exam, whether it's doing prick sensations, but they're doing it over clothes. Well,
Yeah.
that's not really the best way to go about doing a feel sensation test. But if you didn't have it recorded, you would have never known, and if you don't know what to look for, you would have never been able to call it out.
Yeah. And the other thing, it's the same doctors every case.
Yeah, yeah, it's the same doctors, unfortunately, and the ones that sometimes there will be a new doctor that will get into it and because they'll be in vogue or because other defense doctors have been played out. And, the insurance company just runs them ragged and runs them down and they ruin their credibility. And that's just sort of the sad state of affairs of the medical legal defense side of the bar.
Yeah. So you can be examined either by your PIP carrier, or you can be examined after litigation occurs by a hired retained expert. And if your insurance company is asking you to go for a medical exam before you have an attorney, it could be,
Uh-oh.
yeah. I mean, because again, they're going to appear friendly, like they may be on your side, and then all of a sudden you get the report and it says you're not hurt or you don't need any further treatment, or and again, the duty is such a big issue because when you go to a treating doctor, when you hire a doctor, they have a legal duty to you to be correct and to operate within a specific standard of care. A hired retained expert owes no duty to you. So they could be wrong and it doesn't matter. There's no responsibility of the doctor to you. Another issue that comes up is surveillance. We see that, anytime after an accident, it's likely you could be surveilled. Although I don't know from your experience, are you still seeing the same level of surveillance as we did in years past? I mean, there's so much now with social media and everything else. I mean,
Yeah,
you
I do still see it. I think it may be a little bit. A lot of times, what I see is me learning about surveillance, but because the surveillance actually doesn't do any benefit to the other side, I don't actually get the surveillance.
yeah,
So I learn about the surveillance, I learn about it existing, but I don't actually get to view it because they're not catching my clients doing anything that my clients said they couldn't do. I also think surveillance is used in the litigation component to kind of be like an external pressure force on the plaintiff. That is that, if you can find that someone's following you around in a tinted van, going to the store, dropping your kids off, and you see that or feel that, you're going to feel a certain kind of way about it, and you're going to feel stressed about it. I think it's a normal thing. Am I being watched? So I think they use it to that extent too, because a lot of the times the things they're filming, I mean, they're absurd. They're literally someone getting in their vehicle and driving to their child to school and coming back. I mean, what's the value in that for an insurance company? I don't think any. The secondary value would just be the pressure or annoyance or, I guess aggravation that they're causing the plaintiff, which all those factors you might not realize it, but those things are useful tools for the insurance company because they can help discourage your participation in the lawsuit.
yeah. I mean, so in ways that I've seen surveillance used, and again, it can be tricky because they'll take your statement like right after the accident, and so you might feel I can't do anything. I can't, and all of a sudden, I mean, they'll get surveillance of you doing something as simple as, like you say, getting in your car. Well, they didn't appear to have any difficulty getting in their car, any difficulty walking,
So,
I mean, or they took the garbage out. everyday activities that you do, that doesn't look injured. And you may not. The thing is with the with the surveillance. I mean, they're there watching, but you're getting like a snippet of video when they decide to record, so you're not getting an accurate overall view of what's going on with the person. You're getting, a snippet that's designed to try to make it look like A, you're not injured, or B, you're being untruthful about the severity of your injuries.
Yeah, and you touched on it with social media. I think there are different avenues of surveillance now that are coming out more and more, that I see, uh, that are very invasive for people. I mean, when you tell people, "Hey, you're wearing a Whoop watch. I want to read your statistics from before the accident and after the accident." I mean, people get, that's like, whoa, that's like my personal information. And I think the courts are sort of in a modern world kind of going towards creating an avenue where that information can be collected on the defense. Even now, if you think about traumatic brain injuries, and this has come up a few times in cases where if someone's complaining of a traumatic brain injury, how does that correlate to their screen time? What kind of typing rhythms are they using? I mean, if someone's claiming of a traumatic brain injury, but after an accident, it's showing that they're, engaging more with friends and followers. They're writing, clear sentences. Maybe their typing skills have picked up, or little things like that that are electronic that follow us from our cell phones. I think can be useful tools for the defense if they can get their hands on it to try to show that maybe your injury isn't what you claim it is. And it doesn't even mean that those statistics or information is actually showing that. It's just it's just pieces of information that they're getting to use for their narrative, which is you're not hurt. And if you are, it ain't from the accident that we're here to insure you for.
Yeah. So, what do you think about posting on social media?
Y- As a lawyer, this is like one of the most kind of interesting conversations that you have, because specifically in the newer generation, I can see a lot of the younger clients when I talk to them about social media. It's almost like a glossing over of the because they're like, I ain't getting rid of it. Um, it per- Personally, I don't like social media because it's just more evidence to be able to use against my clients. But I would say that to the extent that you're going to use social media, you're going to keep it because you want to be engaged with your friends and family. I get it. I have social media, so I understand. I would say you have to be super careful in the way that you engage with people and what you say. Well, another trial that I had, it was one of my first trials ever. The young girl, super sweet. She was in a terrible accident, hit from behind by a drunk driver who blacked out. So, I mean, this is, it was a pretty serious accident. And she had posted on social media, "Hey, everybody, I'm fine." Okay. That comment, that post was actually taken by the defense firm, and the defense lawyer was waving it around in the courtroom saying, "Look, everybody, she's saying she's fine." Now, obviously, that didn't work with the jury, because what did the jury see? Well, obviously, she said she was fine. She's just trying to tell her family she's not dead. She was hit from behind by a drunk driver who was blacked out, going 55 miles an hour, crushed the car. So but that snapshot, "I'm fine," was taken and used against her. And so I do think that you have to be super careful in how you engage with social media, and just know that after an accident, I mean, I'm telling you, I've had judges order my clients to have to, over my objection, over to download their social media. So I'm talking direct messages. I'm talking what photos you like. I mean, things that are so invasive and and actually, to be quite honest, misleading. Because I mean, I think anyone who's been on a social media platform, if you're scrolling and you had to go back and stand by everything you liked, whether it was intentional or unintentional, accidental, everybody's clicked a like button accidentally at least once if you spend more than an hour on social media, in my opinion. So then all of a sudden we're looking at posts and they're liking it, and it can create a lot of motion practice to keep stuff out. But yes, just understanding that that's a possibility. So you're kind of nipping it in the bud from the front start.
Well, I think you should assume if you post it on social media that it's fair game. And, the defense attorney or the adjuster may get on your social media without you knowing and looking to see what they can get, make sure. But even though if you mark it private, if you get into a litigation context, then they can get that information. And like you said, it's been court ordered. And so it's really part of the unfairness of everything. I mean, you're sitting at a light, you get rear-ended, you've done nothing wrong, and now all of a sudden you're put on the defensive like you've done something wrong. You're not telling the truth. You're not injured. It's really the unfairness of the whole thing. And I think, most people that have never been through this, they come through and they're just amazed that that's how the system works. And it's really the same tactics in every case. People feel like they're getting picked on and they're not. This is just what happens in every case. Anything that the insurance company or defense attorney can use to devalue your claim, they're going to use it. So my advice would be if you're in an accident, don't post anything about it on social media. I mean, I know people like to post things and talk about their injuries and this, that, and the other. It just more often than not, they can take something out of context. I mean, think about it. You have a brain injury and maybe you're having your thoughts aren't clear. You have trouble concentrating. What are you supposed to say? What about if your employer, you know, what are you supposed to do about that? Think about the position that the injured person has put in. It's really, really unfair. And we're not, and when you're talking about a brain injury, it's not something that somebody just says they have. This is something that's evaluated diagnostically through MRIs and special MRIs and neuropsychologists and so forth. But they try to take those things and try to, make it appear something that's really not true. And it's really unfair. And that's why we talk about, this really is all in the same context with accurate medical histories, recorded statements, not saying something that's inconsistent, because credibility, the plaintiff or the claimant's credibility is the key to success.
Hmm.
And so I can tell you when I was a defense attorney, the number one way that you undermine a case is you find inconsistencies in the record. We make sure, when our clients go to deposition or they're faced with giving a statement that they're fully prepared. And, we can deal with bad facts. And sometimes people, get a little defensive or maybe they feel like, oh, they're, whatever reason, or maybe they just forget about something that's happened. But those inconsistencies can be case killers.
Definitely. Yeah, gotta stay consistent. And I always tell people, everybody's got a past, everybody's got a narrative. There's always gonna be something, whether it's a prior injury, maybe a prior workers' comp claim, whatever it is. I don't know, maybe someone had a prior arrest, when they were, jaywalking when they were a kid. I don't know. But whatever those facts are, you just have to kind of, you know, take them in stride and let it be your narrative that's just something that you've overcome, instead of allowing it to be weaponized against you.
Yeah, I can tell you a case that I had when I worked for a major insurance carrier, and I was brought in at the last minute because it was a bad faith case and there was limited coverage, and they thought there was going to be a huge verdict. So they brought me in to try the case, and kind of feel bad about it now. But the claimant had been in a head-on collision on State Road 60 and had multiple fractures and some surgeries, and I didn't even know what I was gonna cross-examine him with. Like, how do you cross-examine somebody like that? And when I remember going up, when it was time to cross-examine him, all I had was some chiropractic records. And, he'd had some prior back problems and treated. But during direct examination with the plaintiff, he'd mentioned some things. So my first question out of the gate was, "Well, of all the injuries that you have, I mean, how are you feeling now?" And he's like, "Everything's resolved except for my back. I'm not having any trouble." I mean, you could show X-rays. I mean, I would have had X-rays and blown. They didn't do any of that. I said, "Really? Okay. Well, did you ever have any trouble with your back before?" "No, never had a problem with my back before." Well, I had records. So I went through the records, and the way you do that on a cross, you start generally. And then you start, well, did you ever any back problems? Well, did you ever treat for your back problems? Did you ever treat with Dr. XYZ? Did you ever treat on November 23rd, with, whatever date with Dr. And you keep going through that and you build across. No, no, no. And I had the records right there that contradicted them. It was funny. The next morning, I show up for trial. The plaintiff's attorney thought that they would rehabilitate it by bringing that chiropractor live, which they weren't going to do. And I got to go through the whole thing again with them. And on a case, I mean, it's probably about $250,000 in medical bills.
Yeah.
Jury awarded them 40 grand.
I have a question about that, Joe. That's such an interesting story because, like, do you believe? I mean, interacting with that plaintiff and his testimony in that case, do you think that he was lying, or do you think that he viewed the chiropractic care as like general maintenance, that it wasn't actually like the same as his orthopedic injuries? Like, how does he get there, and then how does that happen where you have the records? So I'm assuming they have the records. They called the chiropractor. Like, how is it that that guy is testifying that he's never had a back problem when you're sitting there holding records showing that he's got prior chiro?
I honestly believe, because I saw it enough from the defense side, lack of preparation
Yeah.
of the plaintiff for the examination, because compared to everything else that he had been through, like, these chiropractor records were insignificant. But what happened was he blew his credibility, and the jury didn't believe him. And so the jury, once that happens, and I'm telling you, anything, that's why cases almost have to be virtually perfect. I mean, they might give you a pass on one or two things, but that's why we painstakingly go through records and make sure our clients are informed. That was a lesson I learned doing defense work. And so I don't ever want, my client, making those misstatements or missteps in their case. But I can tell you, when I was a defense lawyer, I saw it a lot, where people weren't, and I'd have the records right here. I remember one time I was at a mediation, the guy said he'd never been in any accident. I had delivered at the mediation medical records where a guy had been in a rollover DUI case, like 3 years before, that he never disclosed. Blew the case up.
Oh boy.
So that's what I'm saying. Bad facts can be addressed.
Hmm.
I mean, there's no perfect case. There's always going to be something. It's not like fishing or shooting fish in a barrel. There's always going to be something that can come up, but you handle those in a logical and a reasonable way. And denying something, unless what we would tell somebody, unless you're 100% sure that you've never, one thing that kills me is like, have you ever had a headache? No.
Right.
I mean, come on. Everybody's had a headache.
Yeah, that gives me a headache when they say that.
Yeah. And it may not be like the headache you're having now.
Right. It's not a migraine, yeah, perhaps, or maybe it's
But to say
vocalized
that,
different.
in your life, you've never had a headache.
Yeah.
Like, that's when it gets me.
Yeah.
But, it just goes to show that, like, it matters who your representation is. It matters how well you're prepared, because it's a minefield. And even though you think, well, this is, straight up. I mean, there's no issue here. I'm sitting at a red light. This guy rear ends me. But even like you said, you had this poor young lady with a traumatic brain injury getting smashed in at 55 miles an hour, and they're taking a Facebook post out of context, trying to, convince a jury that she's not hurt.
Yeah.
I mean, it's just, that's the unfairness of it all that I think it's really, with people, you think, well, I have this premium, I pay for this policy, my insurance company is going to be with me, they're going to stand behind me. And it's a battle. Every case, it's a battle.
Yeah. You have a unique, just, I guess, past with this. So it's interesting to me because my entire practice has been on the plaintiff side. I've never worked for, I've done some defense work as like personal counsel, but I've never been hired by an insurance company or worked for an insurance company to defend someone. And I like it like that. I love being on the plaintiff side. I love being able to help people get the compensation that they deserve, help them seek justice and peace and closure for this terrible experience. But on the other side of the bar is the defense lawyers, and I've, you're such a good guy. Everyone that everyone that knows Joe knows how, generous and loving he is, and his family, and it's beautiful, and he's a good man, he's an ethical man, a moral man. How does that, with, taking that persona that you have in your background, how does a lawyer get up in the morning and do the defense work and do the insurance work where they're the ones who are hiring the experts to come in and tell people they're not hurt? I mean, what's the mindset of your colleagues at the insurance company back in, the day when you work there? I mean, is it just a job? I mean, do they kind of become numb to it, or are they secretly grimacing and saying, I really wish I was on that plaintiff side of the bar?
Well, everybody has a right to representation,
Absolutely.
and so I can just say from the defense side, when I did it, um, I'm like thinking about the trials. I don't think I ever called an IME doctor. I don't think I ever called. I just don't believe in like a doctor that's going to say you're not hurt when it's obvious. I think, I took a look at the case, and my job as a defense lawyer is to protect the insured. So my job when I was a defense lawyer is to assess the risk and then convince the insurance company to do the right thing to protect my client. And sometimes it became adversarial between me and the insurance company. Well, I worked for the insurance company, so I didn't care, and they're going to send me cases. But if it's a private defense lawyer and they're like, that's their customer, and so technically and ethically they represent the insured, but yet they're dependent upon the insurance company to send them work. I think that's an interesting dynamic. With me, I didn't, and if the insurance company took an unreasonable approach on something, I would say, you can do whatever you want. I just want my client indemnified. Whatever the verdict is, you promise to indemnify my client, and we'll see what the jury has to say. I mean, and sometimes there's just legitimate disagreements as to value, but I think that I learned in my prosecutorial days, it wasn't about just getting convictions. It was, as a prosecutor, your duty and your job, your ethical responsibility is to seek justice. And I think from this side too, I've always carried that mantra. And I think, we don't represent people that are faking an injury or people that are bringing and the same thing with the defense. If it was a legitimate case, I would tell them to pay, you know, um, but I think, the number one way I defended cases was inconsistencies within the record. Um, for instance, and this is a problem in Vero because there's a lot of primary care doctors and a lot of doctors, once they hear you're in a car accident case, they don't want to treat you for it.
Yeah.
So that'd be one of, if
Why didn't you tell your
you've got a
primary?
primary care doctor for 20 years,
Yeah.
you're in a car accident, you don't tell them about it
Right.
on the record. You've gone
Yeah.
back and maybe, in fairness to the claimant, like, well, they said they weren't treating me, so I'm not going to tell them about those issues from the
Mhm.
car accident. That isn't how they're going to use it. Just like they'll take that statement out of context in your social media, they'll go back and look at those records. Well, you saw this doctor for, a cough or a cold. Not once did you mention that your neck was hurting or your back was hurting or whatever injuries. And so, you know, that becomes again an issue. And it's all about credibility and consistency. And like I said, when you take a deposition, I would mine through the records. I would know everything that you ever complained about and then get those records. So when I went in to take a deposition, if somebody wasn't truthful, it undermines their credibility.
Yeah.
And that's how cases are defended. So, um, the one case I really do feel bad about is the one telling you about where he got the 40 grand. But, I was doing my job and, um, in that case, the plaintiff's attorney really didn't do their job. And
Yeah.
so, but I do think the key for my clients now is that I learned a lot from defense tactics and what they do and bringing it into our practice where we, help clients navigate those minefields so that they're not falling into those traps. So, I mean, representation is important. Representation that has been and seen both sides of it, I think is important. Um, and we've learned together the things that really push the buttons of the insurance company that make them take a harder look at something or reevaluate their position. And a lot of things that we're talking about early on, I mean, maybe it's admissible, maybe it's not admissible, but the insurance company is going to take a particular view of your case from the outset. And, you know, most people I talk to, they're not dying to go to court or litigate their case. It makes it difficult to settle the case once the insurance company takes a particular outlook or view of the case. You have to convince them that their initial assessment was wrong. And that's why these early things really become important is into getting something resolved timely. You've probably seen that a lot.
For sure. Yeah, you gotta those initial steps. You'll see the insurance company because you know, all the other lawyers maybe who are listening already know this, but for the non-lawyers listening, we get a lot of clients referred to us from lawyers who maybe didn't handle the case. Maybe it was a little bit, and it's okay. We appreciate the referrals, but a lot of attorneys maybe feel that they can get involved in personal injury or feel that they can handle the case, and then 8 months later they're kind of realizing they can't, and so they bring it to us, and that's where I see the biggest difference because you're right. When someone comes to us right away, we're already knowing the playing field. We're strategizing from the get go so that we don't have to, I guess, rehabilitate these problems that can happen on the front side because people aren't prepared or haven't been to trial and with some of the best defense litigators in the country like we have. So we've seen the tactics and how it kind of plays out, not just in front of a jury, but in front of the judge and in terms of your bargaining power in mediations and arbitrations and things like that.
Yeah, exactly. So I think the point of it is when we're talking about the edge of right, as we talked about in the beginning, it's these small decisions. This may seem, you know, not that important at the time, but these are small decisions that are made and things that are done during the pendency of a case do affect outcomes.
Definitely.
It's important that if you're in an accident and you're significantly hurt, and you have to seek medical treatment and whatnot, that you have legal representation so that, you're not navigating these minefields by themselves. I mean, we've taken over cases from other lawyers or people that have tried to represent themselves because they think it's going to be, they just got to write a letter and then they don't. And then all of a sudden now we're given this case that has
Yeah.
a lot of issues that we have to try to overcome. And, I think we're pretty good at doing that, but it just makes everything, it delays the claim, resolution, and it just becomes more problematic trying to get to, a resolution. And all we're seeking to do, and I always tell my clients this, we're not, getting in an accident is not a lottery ticket. It's not a payday. It's trying to do what's just and what's right. And so that's where we are. That's what the courts allow, you know, and you'll see publicized these seemingly outrageous verdicts when you don't have all the facts, and maybe some juries get it wrong, but most juries get it right. Most courts get it right, and that's our system. And no system's perfect, but I think it's the best system in the world.
Yeah, it is for the citizens of the United States. That's true. It is the best system that I've yet to come across when you're looking at it from a comprehensive, um, I guess, place, or looking at it from a comprehensive vantage point. Uh, because even though I disagree that you're going to get a jury of your peers necessarily, I disagree that you're going to get a unbiased judge necessarily. Um, but those types of issues and problems, you can deal with them accordingly if you have a competent counsel, and it won't prevent you completely from being able to be made whole, which is ultimately, the best chance that the best hope that you can have after being in an accident, specifically one where it's catastrophic. Will there be compensation paid at the end? Yes. If you come to our firm, will it be fair and reasonable in light of the circumstances? Absolutely. I hope to do even a little bit better than that. But you're right. It's all going to just go towards that ultimate goal of making someone whole, which is often, the struggle that we face when we're representing clients, getting them to that place.
Yeah, I mean, when I say reasonable and fair, we want it to be fair, not a penny less, but we're not gonna just settle a case because it's convenient or it's easy or we don't wanna do the hard work. I mean, litigation is hard work. I mean, there's a lot of deadlines, there's a lot of hours that go in to preparation, making sure that all the little things are done. It's the little things that add up that make the difference in a case. That's what I mean when we talk about the edge of right. You mentioned something earlier about, videotaping medical exams. Not all attorneys do that.
No.
And, that can become super valuable um, because there's no way to know if you don't do that, that what they put into a record, whether that's accurate or not. I mean, you may see someone trying to go through the physical exam and wincing in pain or unable to do something. Guess what? That probably doesn't make it into the record if there's no videotape of it.
Yeah. With those exams too, I think this is I told our firm's cap on this one because I think we were sort of the first to do it, and I know that examinations, CMEs, IMEs, as they used to be called, compulsory medical examinations is the acronym. Independent medical examination is IME. They're not independent. We talked about that in another podcast, but when I first started, I remember I was Joe. He would go and film these things. So I would actually go with a camera recorder to these examinations, and I started noticing. I'm like, why are people getting into medical gowns? What is going on with this medical gown? Because I'm like, they're not even getting into medical gowns at their own doctor's appointments to these orthopedics. They're going to this defense doctor, and the defense doctor is in a court reporter's office, that he's rented, telling my client to get into a medical gown. And so and I mean, sometimes this can be a very awkward experience because
You actually had to get a court order to stop that.
yeah. Yeah, so I started doing that. I started going out and getting court orders and arguing with judges. And now I've seen that other firms have picked up on that. And now they're starting to do that across the state where it's actually coming from the 19th Judicial Circuit, which is where we practice primarily, where we're based out of our home office. We actually got that into the order that is the standing order for CME guidelines in this district and circuit rather. And from that, I now see it in other circuits. So I really think that's like an interesting thing because I prior to us moving for that, I had never heard of anyone trying to prevent their clients from being in a gown by a court order via a motion for protective rules. And it's just another example of what the defense will try to do at every turn. The reason they want you in a medical gown in these CMEs is because one, they're trying to give off a cloak of like legitimacy that it looks like it's a medical exam. But two, it's putting the client actually in like a vulnerable state. They're exposed.
Intimidation.
Intimidation, and now they're basically without clothes or feeling protection in this medical gown with their undergarments underneath it, and you have a strange doctor who is not doesn't have your best interests at heart, trying to perform the examination. So it's really an indirect way at disparagement and things like that, and that's why we've been able to have really great success at convincing judges that it's ludicrous to require that. Is if there's a scar from a surgery, there's other forms of clothing that will allow the doctor to see it. And so, yeah, that's just something that we saw. We were at the forefront of nipping in the bud, and from that, other lawyers who have seen us and seen our success on that have taken it and run with it. And that's for like every other major firm that you can name. If you see that, they got it from us. I'm telling you, nobody was doing that. None of
You've
the
always
firms
been aggressive on that.
Yeah, of course. It's shameful that they even tried to do it, or that it existed for a period of time before us.
But we just have to make sure our clients are protected. And imagine how intimidating that would go into a strange office. And a lot of times when they do CMEs, they're not like in a regular medical office. They might be in a court reporter office or something like that. And then, asking you to take your clothes off or whatever. I mean, it's just ridiculous. So, the thing is we want to get to the truth. That's the number one thing, but the truth has to be protected. And the truth has to be protected by doing these little things. Because for instance, with your videotaping the medical exam, it can appear or seem to be something that it's not if you don't have that type of evidence. And that's one of the things that are just the little things that we do. There's a multitude. I don't want to give away all our work product and secrets that we have, but because I think that we have a lot that are unique to our firm
Definitely.
that we do. But I think that, protecting the truth, and that's what we talk about edge of right. The edge of right is standing firm, and standing constant and being ethical. And it may not always be easy. It may not always be convenient, but you got to be willing to do it. If you're going to take the responsibility to represent people in probably one of the worst experiences that they've ever encountered or going through in their life, to me, if you're not willing to do those things and stand by for your client and stand up for your client, then you really shouldn't be practicing in this space.
Yeah. I had a defense lawyer. We had a client whose uh, family member was with them, and the family member of the client in the accident, and so the family member wanted the client wanted their family member to sign up with us as well. The family member wasn't quite as hurt as the original client, but because of the same accident and because of their family relationship, we agreed we would help and try to do everything we could for both of them. And I remember the defense lawyer came to me and he said, Matt, I understand this client that you represent, and we're gonna deal on that. But the family member, you don't usually handle those types of claims. You handle, more serious and significant claims. And my response to him was, well, that's true, and you just haven't realized it yet. But this one's going to be significant too for you and your insurer. And we got a chuckle out of that. I ended up being right. But it was interesting because I think that it was our firm, our reputation, and just how we're known in the field and how we handle cases that he was from his first step kind of trying to maybe undermine my confidence in the case. But which is funny, but also at the same time kind of indirectly recognizing that our firm and our reputation can sometimes get things done just by itself. It's amazing to me that I can sometimes put our words on our letterhead and maybe say the exact same thing that two or three other lawyers had said before, but it's our work product, it's our letterhead, and it's our words that actually get it done. Where those same types of tactics were just completely ignored with prior lawyers. So I think that's been great for us that we've been able to build that, and not only helps our clients because they're already coming to a place of our firm is reviewed, looked at as with legitimacy, with respect, and with just honestly fear from the defense firms and the insurance companies because they know it's going to be a battle if they want to make it that, and so it's oftentimes better for them to just bend the knee on the front before they have to do it in front of six jury members.
Yeah, I think, if you recall back to when you first came to the firm, that I talked to you about that. And it's always been important to me since the founding of the firm that, you focus on your work product, you focus on doing a good job, doing the right thing, and then everything else follows, but you can't cut corners. You have to, again, do the little things, and you have to be willing to take the inconvenient path or the harder path in order to achieve justice. So, I mean, I'll leave off with one last war story. This is when I was on the plaintiff side. And this is where truth has to be safeguarded because sometimes a case can appear to be something, but that's not really the truth. So we had this case and we represented this family. This man was crossing the street in down at Riviera Beach, and he was hit by a car and killed. And the police officer, the accident investigator, put him outside the crosswalk. That was a big issue, whether he was in the crosswalk or not.
Mhm.
Because if you're in a crosswalk, a vehicle has a duty to yield to the pedestrian within the crosswalk. That's the law. So it became a really big deal. It was this guy just jaywalking. He was basically, just at lunch and was crossing the street to get something to eat. And then, it's something he did probably every day he worked there. And so the accident investigator, the police officer said, no, he's outside of the crosswalk. And, we know because we found pieces of his clothing. One in particular piece was a button off of his jacket. And, I took enough high school physics to be dangerous. I'm by no means a, physics major, but I know that if you get hit, the body and the button is going to assume the speed of the vehicle, and it's not going to just drop straight down, which is what really the conclusion of the officer. So before trial, I mean, this I was brought in late. Another lawyer had worked up the case. And so I decided to go have a conversation with the accident investigator. And I'm like, this is the one thing I just don't understand about how you came to this conclusion because, what I previously explained. And during the conversation, he looked at me and goes, you know what? You're right. He was in the crosswalk. I was wrong. And can you imagine the surprise of the defense attorney when he got up and testified?
Uh-oh. Yeah.
He got up and testified that he made a mistake.
Yeah.
And they were so sure in their case, they didn't even put on damages defense.
Yeah.
But the jury found in our favor. It was a big verdict. And, it all really came down to making that phone call, taking the time to go see that accident investigator. And not in a, usually when you try to talk to police officers and try to tell them wrong, they get a little defensive, but in such a way where, and to his credit, I missed the boat on this one, but totally changed the outcome of that case. And those are just, that's what I mean when we're talking about safeguarding the truth, because that was the truth. Even though the truth may have appeared to be something else, that wasn't the truth. That was a perception based upon, an analysis that was actually incorrect. The correct analysis showed that we were right. And so we talk about the edge of right and doing the things that are difficult and standing fast and standing hard and protecting the truth and getting to the truth of a case. I mean, it starts from the beginning, continues on through trial if that's necessary or to whenever the case resolves. But that really just taught me something, every case, there's so many little details. I think we've always talked about this since you've been here.
Yeah.
That's so many little details that if you're not paying attention or you don't have the time or you're not doing the things that you need to do to really know those things about your case, it can have a significant impact on the recovery. In that case, it would have been an unjust result.
Mm-hmm.
So, with that, do you have anything else to add?
No, I'm just, happy to be here at the firm and happy to be speaking to everybody in the audience that's listening. And, really just looking forward to this, to taking this new brand and running with it and continuing to do what we've done and then continuing to build off that success. So,
yeah, I'm really proud of our firm and our name and what we've done and the reputation that we have in this community.
Yeah, it's awesome.
That's everything. Like I said, from the beginning, that was the most important thing to me in founding a firm was just to make sure that you're respected. And when they do see that Graves Thomas letterhead come across their desk, they have to pay extra attention because they know that we're not going to miss those details.
Because they're going to be paying extra. So
They're going to be paying, they're going to be paying fair, but they're going to be paying more than they might have paid otherwise
if they're smart.
if there was representation that didn't do the things that we do here. And I think our work product and our approach to cases is unique, and I'm very proud of it. And I would put our results against any firm. I don't care how big you are or what your marketing budget is. I would put our results against anyone. And I would put that's including trial results. We've tried cases against the biggest firms, the biggest companies, and we have the resources to do so. So if you've been injured in an accident in Indian River, St. Lucie County, Brevard County, or anywhere in the state of Florida, look us up. Go check out our website. Give us a call. Consultations are free. Attorney's fees and costs, you don't owe them unless we win. Thanks for listening.
Thank you, everybody.